Now back to the show. This is The Law Show on CL 650.
Help, I need somebody help, not just anybody help, you know I need someone.
Welcome back to The Law Show for this Sunday morning. Sterling Fox joined by David Halkett from Macquarie Hunter LLP in Surrey. David is a family lawyer. He and a couple of associates are the family law section at Macquarie Hunter in Surrey. David, we were talking about the recent Family Law Act, the one that came in a couple of years ago, about 2.5 years ago now, here in BC. And we talked about one of the paramount pieces, and one of the main reasons, obviously, was time to refresh the law, which is always struggling on a good day to keep up with technology and societal changes. So this was an important refresh, but it also repositioned the law slightly to at all times be cognizant and aware of the best interests of the child. That's numero uno at all times.
That's correct. Under the Family Relations Act, the previous statute, it said that the best interests of the child were paramount.
Right.
Now it says it's the only test that the court looks at.
Okay.
And so it brings it more in line with the Divorce Act, which was best interest only. And also it broadened what you looked at to some extent. We always looked at who was the primary caregiver, where the children resided, what was best for him and who took care of him, etc. But we also now specifically we look at family violence. And its various ranges from what we consider just physical violence through emotional, economic violence, etc.
Right.
We look at all that, and specifically the impact on the children.
Does the law refer to this new Family Act? Does this speak to this in legal language about these nasty bits of possibility in family life?
Well, what it will do, it specifically says in the Act that you have to consider family violence and the impact of the children when determining what is the best interest of the child.
Of course. Now, that said, I'm just going to run this one by you because, and I know that you're a reputable guy working for an established Vancouver firm, but you hear stories, and again, this
Surrey,
is
actually.
I'm sorry, Surrey firm. I'm sorry, I'm thinking about two things at once. Back in the day, you hear stories of lawyers who, shall we say, unscrupulous lawyers, who would advise their clients, male or female, to include allegations of violence in their petition for custody. To sort of tilt the scales in their favor. An unscrupulous, decidedly nasty tactic that we know from time to time used to happen. How frequent does that happen nowadays in the new era of the Family Law Act?
It's I would like to say that and hope that it's very minimal, and it certainly would be bad practice and certainly, in my view, reportable to our governing body.
You would have to think so.
Yeah, and it's difficult now to see because there's somewhat lawyers always seem to have family violence cases.
Right.
So you always kind of in the back of your mind. But now it comes up in most cases because it actually is listed in the Act.
Right.
And so it's an obvious thing. We all have to screen for family violence when our clients come in. So we have to ask if there was violence, by whom, what it was, whether it was emotional, verbal, physical, etc.
And so do you even get cases where, for example, a mom sitting across your desk trying to describe her side of the story, they fought with family violence, and at the front of my mind here, David, mom will say something like, well, he used to give the kids the strap when they stepped out of line, and I didn't like that. I thought that was inappropriate. Now, Canadian law allows for that. That's not considered family violence if you discipline a child with corporal punishment. It's a decidedly dodgy area.
Very gray area.
Very gray area. But in terms of the facts of Canadian law, it is still permitted. But have you heard cases like that?
Oh, yeah.
And is that considered family violence?
It can be, especially if there was if a belt was involved or a weapon.
Yeah.
Then certainly that goes above the normal, just the spank.
Right.
That our courts may say that's really not bad, depending again on the severity, the how frequent it is, and whether or not the child was actually injured. So if you just tap your child to get them into line, that's probably fine. If you're giving them, the equivalent of the old 20 lashes, so to speak, that would be over the line, certainly violence, and would definitely be a factor.
David, how many cases, give me a ballpark percentage of cases, divorce cases in British Columbia, involve family violence?
Well, do you mean physical or the emotional?
Any
and verbal?
kind. Because you're right.
Yeah.
I think emotional can be as nasty and perhaps even more so than outright physical
Yeah.
abuse.
And the problem with determining emotional and verbal is that it's a very subjective
Sure,
area.
sure.
Like I've had people
And more
come-
insidious in many ways.
Exactly, and you can really grind the person down with name calling
Mm-hmm.
and economic, that I'm more economically powerful than you, that kind of stuff.
Bullying
so,
stuff, huh?
Exactly.
Yep.
So in my cases, it's probably at least half that have
Interesting.
some kind of an aspect of it.
Right.
Some will say, yeah, we called each other names, but I was involved too. Right? So that to me, that offsets it to some extent.
Right.
But outright violence from one side solely on the other, maybe a third to half in my cases.
And how does that shade, typically, the outcome of a case if you can identify a pattern of violence?
Well, it depends on if the children were exposed, and if so, how.
Right. As in
and-
physically or mentally injured in some way.
If it was directly on them, or if they've witnessed it happening to their mom or their dad.
Right.
How it affected them. And so
That's the other part we don't think about. Adults don't think about when they're
Exactly.
off against each other, screaming and yelling. There are witnesses here who are
Exactly.
extremely unhappy about what they're hearing, and they're not taking sides.
exactly, they love both their parents.
Yes.
And the tough part is when they end up almost being asked to take sides by their parents, because you know what your dad did to me, or you know what your mom did to me.
Right.
And we're probably all guilty of it to some extent. But the children do
You
get
just
affected.
wait till your father gets home.
Exactly. Yeah, exactly. Well, I'll tell you a funny story. Like one time when my son was really young, my mom my wife, I should say, took him to Safeway. And I was there Sunday. They went grocery shopping. Well, one day he was acting up, and he was like 2 or 3 years old. And she goes, "Okay, you're staying home with your dad." I said, "Why am I the punishment?"
Right.
That kind of stuff, right? You're not coming with me. You're
No going
punished.
out and having fun. Stay home with Dad.
Exactly. So I think but all kidding aside, though, it is a factor that we have to consider in all our matters.
Right.
And what we have to look at is whether or not the party would be able to negotiate a settlement with the quote-unquote violent spouse with proper legal advice, etc. And whether or not, if they're just caving in on a deal, is it because they're actually afraid of their spouse and such. So we have to consider all those issues. And it comes up probably in about, as I said, a third to half of my matters.
What about those little witnesses, David? At what point do lawyers and, more importantly, do judges take into account what those little boys and girls see mom and dad badly behaving? When are children allowed to speak up for themselves in a legal setting?
Well, under the Family Law Act, we have children as young as 8 can start giving their views. It's not a choice. They just get to they get a voice, but not a choice,
Right.
as the saying goes. But starting at 8, and by the time they get to be 12 or 13, if they don't want to be with one other parent, courts tend not to want to enforce it out of fear that they'll run away or do something like that.
Right. And then you get into that sort of manipulation thing. Well,
Parental alienation.
if you come and live with me, we'll go to Disneyland at Christmas, and next summer we'll go to France, and then you can go, and basically the wealthier parent, perhaps, basically bribing the teenager to come live with him or her, exacting yet another stroke of revenge.
Exactly, and child support is supposed to offset that to some extent. That you're supposed to some extent, have as much as possible similar incomes or similar lifestyles in both homes. But yes, that does happen. But what happens a lot with teenagers is one parent has stricter rules than the other.
Right.
So even with the other parent not even saying "come live with me," the child knows that they'll be a little more lax in one house than the other, so they go home.
And back to violent situations, if I might. Let's back it up even further. Let's talk about what it's like. And this is a tough show to do for both you and me, and I know this. I can see it on your face.
Yeah.
This is Christmas season.
Yeah, it
we
is.
just had Christmas 2 days ago, man.
Yep.
This is family time. This is, huggy bear, kissy face time, right? And here we are talking about divorce and family breakup, but as you've already pointed out, this is also a super sensitive time
It is.
for so many families, many of whom are just giving it one last shot before all hell breaks loose. So back to this whole matter of that last shot. When we talk about the breakup of families and people who don't make it through this Christmas, it becomes painfully obvious to everyone that this is not going to go anywhere. So next Tuesday, we've decided that's it.
Yep.
So all of a sudden, there's a very shattered person in your office there at the Surrey Central building at Macquarie Hunter, sitting across the desk from you in just pieces, going, I just found out my relationship, my marriage, is going nowhere. He's leaving me.
Yep.
So talk to us about what happens. First of all, somebody's got to have, maybe they're listening to us right now on the radio going, well, he sounds like a pretty straight-up guy. He sounds like the kind of guy who can listen to my case, and you've been doing it for a long time.
That's
and
correct.
Rule 1 of a good family lawyer is be an excellent listener.
Yeah, we have to be able to listen, because people come in, and the breakup of your family is probably next to the death of a parent or a spouse, is the worst thing that can happen.
Sure.
To a lot of people, at least at that time. It may get better over time. So they come in and they're all over the place. They're emotional. They're either angry. They're stunned if they were told that their spouse is leaving them and they didn't know.
Right.
Or they're sad, or a combination of all.
And do they call you, or do they send you an email? How do they find you?
Well, obviously a lot of it's word of mouth.
Sure.
Through referrals from other clients, or other lawyers in the firm refer. But certainly we have a large net presence, so they find us on the web, and
right.
they call in and then they set up an initial consult.
And it's Macquarie.com, McQuarrie.com. And David Halkett's contact points and email and all of that stuff is on the website
That's
as well,
correct.
as your two associates in the family
That's correct.
law division, and all of the particulars. It's a great website, by the way, and it's a busy firm.
It is.
You can
We
tell
are
by
very
your
busy.
website. So that's the deal. Someone will pick your name up off the radio, perhaps, and then go to Macquarie.com, find out your contact point, and give you a call going,
That's correct.
help. As Dwayne just played for us a few minutes ago, help.
Yep.
Do people just call you up and go, now what?
Yeah, they'll say, I need advice. We're going to be breaking up, or my spouse is leaving me, and so then I'll put them through to my assistant, who will take the conflict information, make sure that there's no conflict for us. And then she'll
As
set up
in
the
you
point.
may have some relationship with the other
Exactly.
party. Right.
Or even another lawyer at the firm may have on another matter.
Okay.
And she sets up the appointment, and they come in, and we meet for about an hour.
Okay. And part of being an excellent listener, I would imagine, in this particular aspect of the law, would include being well armed with Kleenex.
Oh, yes, for sure.
And I would think a fairly empathetic demeanor.
Yeah, you have to let them talk for the first 15 or so minutes. And during that time, they may think they're not saying anything, but I've picked up a lot of what the issues are that I can see. And you're right. When it's a female client, I'll just get the Kleenex, or I'll ask them if they want it. If it's a guy and they're starting to cry, and I have had guys cry.
I would absolutely
And
believe that,
They tend to say they don't need the Kleenex, so I don't ask. I just go walk over, grab it, and put it in front of them.
Right.
And then they'll talk for 15 minutes sometimes without me getting a word in edgewise.
Sure.
After I tried to calm them down by telling them, look at our view and all those kind of things.
Right.
And talk about the weather, whatever. And then once they finish their talk, then I'll start getting more specific. But I've already picked out a lot of what I consider the issues to be.
Because you've been hearing that kind of emotionally shattered declaration now for close on to 20 years.
Yeah, I've been pretty well family law only for 20 years. And practicing now for 23, almost 24.
So again, you know what you're listening for
Exactly.
as they ramble on through their emotional tirade of what they've been through. And this isn't how the script was written.
No.
This is not how it's supposed to turn out, damn it.
Exactly.
And off they go. But you're listening for little nuggets of information through all of that and are able to pick out quite a bit, aren't you?
Exactly. I know pretty well the 3 or 4 main issues that they're going to have and where we go from there. But it's interesting you say that wasn't the script. It's right. I had someone tell me a few days ago, I don't believe in divorce. Well, no one does when they get married. They all think that when divorce is something that happens to someone else,
right?
Not to you. But when it happens, you have to deal with it.
Right. And one of the things that the Family Law Act of British Columbia has allowed people to do more now, David, than ever before in our province is not go to court.
That's right.
In order to resolve their differences, including guardianship and custody and those support
Assets,
issues.
Yeah, exactly.
So now there are various other ways, short of going before a judge and having a complete stranger dictate details of your life that perhaps you were not expecting. Tell us about the other ways that people have to resolve their issues.
The main one would be mediation, where you either with lawyers or without, you have a paid mediator usually it's paid, in the room, and you try to work out common ground and settle up your issues as much as you can between you.
So with a mediator in the room, do the husband and have a lawyer and the wife have a lawyer? So you got to.
They can.
Okay.
Or sometimes they go themselves, because obviously then you're paying 3 different lawyers to be
exactly.
in the room.
Yeah.
What they sometimes do is they can go off to a mediator, work out a deal, subject to getting legal advice on their own. Because the mediator can't give legal advice because he's acting on...
for both parties.
Exactly.
Sure.
So he can't do that. So he's just trying to find a common ground. And that's the main way. And it keeps it out of court, and then all you have to do is go to court for divorce. Because only the court can grant a divorce.
Okay. And that's still federal law, the Divorce Act, right?
Exactly. So if you can work it out, there's other ways. There's collaborative divorce, where the parties have a lawyer, and they may have divorce coaches, financial planners, etc. involved.
What's a divorce coach?
It
sounds like a burgeoning industry
it's interesting.
Kind of a first world problem that we've got here.
They're usually therapists of some kind who assist you getting through working out parenting plans.
Oh, I see.
Etc.
But not a legal person then.
They can be, but usually
legal
they're not.
background, but not a lawyer.
They may have a legal background, or they may just be from the social sciences area.
Okay, right.
And so then you have a series of meetings where the lawyers have agreed not to go to court.
Oh, okay. I have a very interesting case that David brought along with him today, full of initials, and we'll get him to explain why that is. We're going to talk about residency. This is an issue that, as we become even more and more mobile, and it's going to become even more so as time goes along, that very much, dramatically in many cases, affects the decisions surrounding custody and guardianship and support matters. We're going to talk about residency on The Law Show with David Halkett from Macquarie Hunter LLP in Surrey at Central City when we return here on CIL 650.
There's more of the show still ahead. This is The Law Show on CIL 650.